Hello and welcome to tutorial key point video number 3 for W200. I've already made a video about getting high marks in ETMAs, and I'd encourage you to have a look at that and the table that accompanies it. And we dealt with that in the tutorial. But the other issues that we looked at were TMA 1 itself. Key points from that is the different meanings of civil law, the different meanings of common law, and the differences between civil and criminal law. I saw a number of brave attempts to try and bring together the different meanings of civil law and the many different meanings of the term common law. In fact, they are very different meanings, and only by the context can you work out which one is to be done, and you can't actually mash them together. And so when necessary, I will have put on your comments that it would be valuable to make a table setting out the different meanings and the contexts in which they come up. Another table that would be useful to do, certainly for revision purposes, is the differences between civil and criminal law. As many differences as you can find, and should it come up as an exam question, and it frequently has, you'll be in a great position to write some good stuff there. We then looked at what we're going to be doing between now and the next tutorial. So we looked at the principles of human rights. We contrasted the traditional approach that an Englishman was free because he could do anything he wants unless it's specifically banned. Well, that was fine up until the 20th century, when it was realized, first of all, that that was great for societies where government actually didn't do much. Where we have a modern, complex society, governments can themselves be a threat to human rights and civil liberties. But also we saw in the 20th century some of the awful things that could be done in terms of genocide, of taking away people's rights by governments. So we've moved to the more modern approach of the European Convention on Human Rights. Do have a look at that. Do have a look at what its basis is, and note that it is about specific rights that are protected. It's not a sort of general human rights will be protected. There are specific rights, and many of those are balanced against other people's rights. So my right to say something about you is to be balanced by your right not to be defamed, libeled and slandered. In particular, your manual concentrates on the rights of arrest and detention. Useful again to draw up a table of the rights. I've sent out a handout about this, which set out when the rights arise, what the rights are, what the exceptions are to those rights, and who can bring in to play one of those exceptions. Then we moved on to principles of criminal law, and make sure that you have a good understanding of the concepts of actus reus and mens rea. It's briefly mentioned in that first manual, more detail in the section on criminal law. From that we move on to the principles of obligations. Key question: what obligations do we owe to others, and where do those obligations arise? This isn't the whole of obligations, that's what you'll do in a future course, but it's an introduction to two key areas, contract and tort. As far as contract is concerned, the first question for the courts is there a contract? And that's where offer, exception, intention to create legal relations, which is a presumption which can be overcome, and consideration come into play. They're there for tools for the court to decide whether this is a contract which they will consider enforcing, or whether it's an agreement which they say, no, go away, it's not for us. Secondly, what's in the contract? The express terms, those terms that have been expressed either by words or specifically in writing between the terms, and the so-called implied terms, things that are in effect written into a contract, often by statute, and remedies. On tort, there are a number of different types of tort, and you're just going to be looking at one, the tort of negligence. Again, there are three essentials of the tort of negligence: duty of care, breach of that duty, and that breach causing the injury that occurs. We finished off by looking far ahead to the future into the introduction to EU law. Remember that although the press may talk about Europe, there are many different types of Europe, and the key error would be to confuse the European Union with the European Convention on Human Rights, which was set up by the Council of Europe. Again, I've sent you a table which sets out the differences between them. Make sure that you are fully aware of those differences, because mixing them up is the sort of thing that will constitute a fundamental flaw which could cause you to fail on a TMA or on an exam question. So look at the history of the development of the European Union. An understanding of how institutions and how the laws have developed is a very useful way of understanding the law. That's true of all areas of law. But the history of the EU is much shorter. We are seeing it develop even now. So don't just skim over the history. Understand where the EU comes from, how it's developed, what was the thinking behind the developments. And look at the institutions. Make sure that you are, by the time we next meet, in a position where you can describe the institutions, say who does what, who they are accountable to, who selects them, and so on. We finished off by looking at TMA02 and TMA03. TMA02, question 2, due on the 17th of December, you need to explain what statutory interpretation is and its significance, discuss the need for statutory interpretation, explain, most of all, evaluate the so-called traditional rules, the literal, the golden, the mischief, discuss the relationship between the rules. Explain and evaluate the modern approach, the purposive approach. You can contrast it with the mischief rule. What's the same? What's different? Also, human rights and its impact. Discuss other aids to interpretation. Explain the types of other aids, and I'm looking forward to at least some comments on Pepper and Hart. Finally, a conclusion, which is a conclusion to your argument and not just a restatement. Question 2, the background, the significance and examples, how precedent works, when it's binding and which courts bind which, and the rules for specific courts. So I would expect you to discuss the practice statement of 1966 and how it's adopted by the Supreme Court in the Austin and Southwark London Borough Council case, and for the Court of Appeal, the Young and Brittle airplane case. Apply it to the question. On TMA03, it's a long time away, but be thinking about EU law, the types of legislation and how they're enforced. This is a bit of practice for research, so do have a look at the research ones and do some exercise. It'll make it easier. And explain in your own words. Don't just describe. Well, with those comments, I'll finish off now. Look forward to seeing you at the next tutorial, and of course receiving your next TMA.